Do you know how many people are watching on live stream? You have any idea?
Yes, it tells us we've never hit double digits.
Okay.
But it does get viewed. Sometimes it gets viewed after the fact because it gets saved, and so people can access it anytime and watch it.
Yeah.
The CLE, the subcommittee, that the ethics committee that's looking at rule amendments related to 8.4 and all of in the preamble, they've had around a dozen or so at some points, but we've been a little less than that. We are. We're good to go.
I'd like to call the meeting of the CLE Board Subcommittee on Bias and Diversity to order, and remind each member of the subcommittee that they have a duty under the State Ethics Act to avoid conflicts of interest or the appearance of conflicts, and they should refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest or an appearance of conflict. Having reviewed the agenda, does anyone know of any conflict at this point? None appearing. Please feel welcome to this committee meeting, and there are minutes that were provided to you with the email that had the agenda. I presume you've had an opportunity to read the minutes. Does anyone have any corrections or modifications to the minutes? None appearing. Do I hear a motion that we adopt the minutes? The second?
Second.
Been moved and seconded. Any discussion? None appearing. All in favor say aye.
Aye.
All opposed, like sign. The minutes are approved. Peter, you also sent us a proposed definition. I believe it starts on page 6 of 8 in your email.
Yes, and I'm gonna go ahead and share the screen here for people to see. This is after our last meeting, the committee asked me to put together a proposed definition that is both inclusive of all the different types of courses that could be offered, and inclusive of the language from the preamble, the proposed language from the preamble. This was my stab at it. Sent it to you to take a look at a week or two ago, and then again with these materials. For anyone who's not able to read it, I'll just read it once. Diversity, inclusion, and elimination of bias training shall mean a program directly related to the practice of law, devoted to diversity, inclusion, and elimination of bias towards persons based on race, sex, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. Programs may focus on, among other things, implicit and explicit bias, equal access to justice, serving a diverse population, diversity and inclusion initiatives in the legal profession, and sensitivity to cultural and other differences when interacting with members of the public, judges, jurors, litigants, attorneys, and court personnel. So that was my stab at trying to make work what the committee had asked for.
Impressive.
Yep.
Any questions? First of all, any questions of Peter? Then any suggestions about any changes in this?
I received one comment. I did send this proposed definition to James Williams, and he just responded with a comment that he would recommend adding clients to the list in the last sentence of the types of people that we should be sensitive to cultural and other differences with. That somewhere there we could add members of the public, clients, judges, jurors, litigants, attorneys, and court personnel.
It doesn't seem to do any harm from my perspective.
Yeah, I mean, I think it's included in members of the public, but I think it's also good to specifically set them out too, since we have all these other named persons.
I mean, a client is presumably also a litigant, but
All right.
involuntary litigant. So. Peter, is this, you said this tracks what the subcommittee on the rules of professional responsibility is looking at. Did I hear you right?
What this tracks is the classes that are going to be listed in that are proposed to be included in the preamble, with one difference at the moment. The current version that was proposed for the preamble includes gender as a separate class, but that's going to be proposed to be corrected because we already are using race, sex, and including sexual orientation and gender identity. So I think the proper terms now are gender identity and sex instead of just gender itself. And so this is already kind of assuming that change is going to be made this afternoon at the meeting for the in the ethics committee that's meeting this afternoon.
It seems right to me that these two should track each other. That when there is an obligation, the training should sort of try to meet that objective. So that makes sense to me.
I believe this probably exceeds the scope of our assignment, but we had talked earlier about that it would be better if, in addition to changing the preamble, we put in a rule about elimination of bias. Has that been suggested to the ethics committee?
Yes, they are studying proposed rule changes. So an amendment to the preamble was approved for publication in the July meeting and was published in this most recent journal and will be up for potential adoption by the council in October. In addition, the ethics committee created two subcommittees to study potential changes to rule additions to the rules of competency to include cultural competency and potential additions to an anti-discrimination rule in Rule 8.4. And those are being studied by the ethics committee now.
Thank you. Anyone else have thoughts about this definition?
Well, one sort of picky point in the second sentence where it says programs may focus on, among other things, maybe we should put the among other things at the closer to the end. Let's start with the specific things there. So we would move that down after other differences and put a comma, among other things, comma.
Okay, I'm going to open up this in a Word document so we can, I can propose these changes right here on the fly here. So moving among other things out of here.
And move it after differences.
Too many Zoom windows up. Okay. Focus on implicit and implicit bias. See, there's
Right.
Is that what you had in mind, Chief?
Yes, it looks like it. It just seems stronger to start it out with the specifics and then throw in the more general at the end.
So just to make a comment for purposes of talking about it rather than not talking about it, you obviously went the direction of enumerating the classes or bases of prohibited discrimination versus the more general approach of New York. And as Jim has pointed out, I gather these classes or tracking what the draft of the proposed amendment to the bar preamble is. So, I was interested in what you said about James Williams' comment, because to me, if there's any concern with this list, it would be that I don't really, all of these are problematic. I think we have a special issue with race discrimination so as I expressed last time, I have some level of discomfort about seeming to put all of these on an equal footing, although certainly you can make the argument that they should be on an equal footing. But I think in terms of what we're trying to accomplish, probably race, is the most important objective, that is to eliminate racial bias. And for that reason, I have some warmth towards the New York approach, but those are comments just in case that elicits any other discussion. I'm otherwise fine with what you did, and I think it's a good job.
Any comments regarding Dixon's thoughts?
Well, Peter, I assume that the State Bar group perhaps had a similar discussion?
Yes. So in terms of the ethics committee, so Brian is here. There was certainly the preamble language was what was adopted by the council a decade ago and sent to the Supreme Court, but was never approved. Was never approved by the Supreme Court, which was the reason that language was once again used this time. I don't have any particular knowledge on whether there was discussion just to have a focus on race, but I think there was always kind of a thought that any sort of discrimination against a protected class should be something that we are working to educate people to avoid.
Okay.
Brian, do you have anything you want to add to that?
No, I mean, I guess I apologize everyone for being late. But as far as what the ethics committee is discussed, and I guess maybe I'm kind of catching up on what was just being discussed, but yes, the ethics committee really, we had a separate meeting in June where we introduced or reintroduced the preamble language that was previously approved in 2010, like Peter said. There wasn't a significant discussion on just kind of on modifying that. It was really just kind of a focus on what was done before, what was approved by the council before, and really it was just kind of looked at as a whole. And I think there was, seemed to be a fair amount of support from the council on the preamble proposal, remaining as it's kind of laid out here. But yeah, this does track, particularly with the protected classes here, this does track the preamble proposal.
Would there be any interest in requiring any sort of standard, that is, such as that the program would have to be science or data based, for instance? I'm just, our job as lawyers is always to think about the worst possible case. And I can imagine some people coming forward with training that we might not think met the sort of validity level? And would you have any, is there any problem with your then discretion at the bar level to approve or disapprove the program?
Well, I think we've tried to create in the past broad enough definitions to allow for a diversity of courses, with the understanding that some are going to be better than others, and that's just the case as it is now with any other course. There's CLE that is approved that is not necessarily the highest of quality CLE, but it checks all of the boxes. I think it'd be hard for our staff to start judging validity of courses based on science and data to know whether one is more valid than the other. I think it would be a hard thing to ask our staff to have to start towing that line and making those kinds of validating reviews.
Right. But obviously, it's just taking on a political cast potentially.
Peter, do we not also have the accreditation committee that can review, at least to some extent in advance, the content of programs to see if they meet the requirements that Dixon is alluding to?
Yeah, and Dixon makes a good point though. If we don't put any sort of requirement that of a course, then it would be hard for us to deny a course because we say it's not scientific if we don't have something in there. But what we've tried to do here is really, there's a lot of different kinds of courses that would fit into this definition. And so we would need to, if we really wanted to have a large list of criteria for what does and doesn't satisfy a course requirement, we'd have to create new rules for it, which is what we did with the technology hour. And honestly, I think Deborah would agree with me that creating a list of courses that qualify and courses that don't, and all of these different little exceptions actually made it harder than to just have a more broad definition. Because it creates even smaller micro gray areas that we have to try to figure out. So that's certainly an option. I mean, that's what we did with technology is we created some rules that really went into more specifics on what courses do or do not qualify, and that's an option that we could go. Or it's an option that we could add in later if we feel that the courses that are not being offered at the beginning are the ones that we had in mind.
Mm-hmm. All right, maybe that's the better way to go, is to see how it plays out.
What kind of review do providers have to go through to be approved for offering CLE that gets credit?
Deborah, do you want to handle that?
I'll be glad to. We don't pre-approve providers, Professor Drennan. We just approve the courses that they're sponsoring. So as long as their course meets checks all the boxes, the course is approved. But we don't give blanket approval to providers.
So it's still a course by course approval.
That's correct.
I don't have any doubt that some of these conversations are political. I mean, we're in a political world, and we're certainly in the middle of one right now. It just seems to me it's going to be fairly hard to construct a regulatory scheme that requires Peter and Deborah and others to make these pretty hard judgments about who's qualified and who's not, or what. I mean, there's a tension there for sure. I get that, and I certainly hope the courses that are offered are credible and based on data and and actually trying to address the issues that this particular rule is mandating. But I think at some point we have to trust the skill and professionalism and judgment of the people who the bar has put in place to make the judgments about what qualifies. And doing that in advance seems to me to be fairly hard to do. I don't know. I mean, as you say, you tried it with technology, but there are a lot of different avenues people can take that are needed. I mean, I don't think any of the things that you listed as possible sort of course objectives aren't really, really important to a system of justice that's fair and does its best to be fair to the people who come through it. So I hear what you're saying, Dixon. I don't know how you address it really in a regulatory scheme.
Well, as I say, I was really just thinking out loud here
Yeah.
to see if there's some discussion to spark around that. But
Dixon, one of the most important parts of this rule that I think has been in all of the other rules of different states is that the programs need to be directly related to the practice of law. I think that'll do a good job of filtering out some of the very general things that could are cookie cutter that wouldn't be as effective for lawyers. And so that'll be something that our staff and when the committee if the committee is reviewing something, that we will be able to really focus on is this program directly related to the practice of law, or is it just a standard course on diversity? And I think that will help us a lot in weeding some things out.
yeah, that's a good point.
Well, that makes me think about some potential small wording change again. Since we're going to be focusing on the practice of law, maybe we want the members of the public to be the last one in that list of people to be concerned about interacting with.
So your proposed potentially, Chief, would be when interacting with clients, judges, jurors, litigants, attorneys, court personnel, and members of the public?
Yes.
Peter, how do you see the members of the public courses being addressed to members of the public? How would that fit into your analysis of whether it's directly related to the practice of law?
That's a good question. I took that language from different states. I think we've talked about whether there is a requirement for lawyers to not discriminate or not discriminate in their personal lives. And I don't know that this intends to teach people how to be better people in general. But there are members of the public that you deal with in the practice of law that are not your clients. I guess that could be other clients, opposing parties, witnesses, audience members in a litigation, complainants in a disciplinary matter. I could see some other members of the public involved, but it's certainly a good question.
Could I make a suggestion, wording suggestion then? In that second sentence, maybe where it says programs may focus on, after that put a lawyer's implicit or explicit bias. Well, I'm trying to think of some way to say that it's the person's duty as a member of the bar, but not his overall duty. I know we're lawyers 24 hours a day, but if you're shooting pool and you say something, you're not saying it as a lawyer.
I guess, George, that's where the directly related to the practice of law comes in at the beginning, that it still needs to be a program related to the practice of law. It wouldn't be just a general personal.
What about the programs may focus on the lawyer, apostrophe S, implicit or explicit bias equal.
I'll jump in real quick and see if Brian has something that he wants to address. He had his hand raised.
Yeah, well, I was just with regards to the question before, with regards to the members of the public, I think that really brings up the instruction or the guidance that we have in our preamble, that what we as lawyers, one of the responsibilities that we have, although it's not necessarily an enforceable disciplinary rule, one of the fundamental values is the integrity of the profession and doing what we can to promote the public's perception of our justice system. And so I think these programs really go to that goal, that we are communicating with those that are directly involved, but also the members of the public upon whom we rely to kind of uphold this institution that is the justice system. So I think that's I think it's a great thing to include the members of the public, and I think we can always refer back to the preamble as one of those fundamental goals that we have, fundamental values that we have as lawyers.
One of the conversations we have when we're talking to judges in various settings is, do you have a duty, and what is the duty to sort of be ambassadors for a deeper understanding of the public about the role of the justice system? And I mean, it goes back to that. How do you build public trust and confidence in the institutions of justice? And so I'm just hypothetically, suppose someone had a class that was preparing lawyers or court officials to do that. Would that qualify?
If it was a class that was related to the practice of law, it would need to be tied into, this is how you would do that in your practice. I think that would be appropriate.
Okay.
Yeah. And I mean, I keep on thinking of and I'm sure you guys have covered the Keller standards and all that kind of stuff, of the fact that anything that we do, if we're going to use mandatory dues to impose a restriction or anything like that, it's got to be for really the regulation of the profession and the improvement of legal services to the public. And I think that could be what you just described, Jim. It could very much be under that umbrella. It's a broad umbrella, but it's one that was set up by the Supreme Court in that Keller case in 91. So I think you could have something as broad as that if it's focused on the practice of law, and regarding kind of the improvement of the overall justice system.
There's certainly parallel provisions in the Code of Judicial Conduct that sort of empower judges who are willing to take that to make that effort to be ambassadors, if you will, for a deeper understanding, which is actually quite a complicated, serious issue right now in light of where we are as a country. It's a conversation I know judges are having among themselves, and there's no reason lawyers wouldn't be having the same conversations.
All right. Okay. Other comments about the definition?
I think it's a good job, Peter.
So do I.
Thank you.
Then do we want to recommend the inclusion of this definition in our presentation to the overall CLE board. Is that the next step, Peter?
Yeah, so that would be the board would, this subcommittee would vote to recommend that the CLE board propose this rule change, this additional rule as an amendment to the CLE rules to the council in October.
So moved.
We have a motion to that effect. Do I have a second?
Second.
Been moved and seconded. Is there any discussion? None appearing. All who favor the motion of sending this definition to the overall board of directors of CLE for the state bar, say aye.
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 All opposed, like sign. It passes.
Great.
Then, Peter, I think we have some time to talk about the procedural requirements that you had sent us. Again, starting on page 6 of your.
Yes. So what I first want to ask is that you disregard some of this in the sense that this subcommittee does not need to be discussing or debating whether the CLE board should recommend a switch to a 12-hour, 1-year reporting period to a 3-year reporting period. That's going to be something that is that's outside of the bounds of this subcommittee that will be discussed by the CLE board. What I why I included this kind of example would be that if the CLE board were to recommend that we move to a 3-year reporting period, I know that this subcommittee had a strong desire to mandate that all lawyers take this training as soon as the rule, becomes effective. And so instead of if we were to switch to a 3-year reporting period, there's a potential that there could be 3 years before a lawyer even has to take one of these training courses. So what I have done, and even in this proposal, if we were to switch to 36 hours, would require each one of these reporting groups, as they would be created, would have to complete a 1 hour of diversity, inclusion, and elimination of bias training in before the 2022, December 31st, 2022. So all lawyers would be required to take this course in the first year of it being required. And then going forward, for example, if we were to switch to a 3-year reporting period, I have it as at least 2 hours of those 36 hours should be devoted to diversity, inclusion, and elimination of bias training. George mentioned that maybe it should be 3 hours. I think that is something that this subcommittee could recommend that the board consider, what annual or triannual requirement it should be, but I think that will probably be a decision up to the board, the full CLE board, as to what they ultimately choose. But this subcommittee could recommend that they would want 3 out of 36 or 1 out of every 12. That could be something that's sent to the full CLE board. But I just did as an example that of the 36 hours, you'd have 6 hours of ethics, professional responsibility, 2 hours of technology, 2 hours of substance abuse and mental health, and then 2 hours of diversity, inclusion, and elimination of bias every 3 years. One of the things this subcommittee talked about was the benefits of having a longer training. And so if you had 2 or potentially 3 hours required, you could take a 2 or 3 hour course. And those have, as Professor Drennan talked about, those can be a lot more effective than just a 1 hour course. And so this having it be a 3-year period with at least 2 hours required would allow more lawyers, probably open up more lawyers to taking a longer course to satisfy their requirements. But I don't think the subcommittee has to vote on a recommendation to move to 36 hours or a new reporting period, but it might be that this subcommittee wants to make their recommendation to the CLE board that all lawyers be required to take this course in the first year of it being approved by the Supreme Court, and then that the CLE board establish periodic training going forward, and then determine whether you want to add a recommendation of how much periodic training you think the board should add.
And in my conversations with Peter, my reason for suggesting 3 years is under the current plan, where the 12 hours per year, it would seem to me that each year we need at least 1 hour of diversity training or diversity education. And I had wanted to follow that through if we do go to a 3-year plan and have it so that it's the same proportion of hours.
So what I did in this proposal is I did both technology and diversity the same, to where instead of it being annual, technology would be just 2 out of every 3 years, essentially, instead of 3 out of every 3. But that, again, this is still early on. I haven't released this to anybody to review. This was just a kind of an idea proposal. Since we are going to be going through a big database redesign this year, this is the right time for us to be at least looking at this to see if this is the right way to go for CLE. But this board could recommend any number of things. It doesn't have to be related to 36 hours at all.
George, I like your recommendation of having at least 1 hour every year.
Now, Chief, would that be in the rule that they actually have to take it each year, or it just be free in the 3-year period? Because that allows for them to take the longer courses. One of the other things we're hoping to avoid is to try to have an annual requirement that is in addition to their 3-year reporting requirement, because then we have to kind of watch the lawyers each year, instead of giving them the freedom to choose how they want to take their 36 hours in that 3-year span.
I understand your point. Yes, that's fine.
My point was just, until we have made a change, that we should require 1 hour every year.
Yes.
Until we change to a 3-hour reporting period.
So you could, right, say you have to do one period of 2 or 3 hours at least once every 3 years, or you could do it, an hour at the time. I mean, couldn't you do that even if you don't go to the 3-year reporting period? Isn't that kind of how some of the other things work? I don't think I have to get,
yeah.
I mean, I'm not, I've been exempt from this for 40 years. And since I'm in semi-retirement, I'm no longer exempt. So I'm a little more aware of what it's like to be on the receiving end rather than the giving end. But, and it's actually simpler for me if it's a requirement that lasts even 2 hours, if I don't have to do it every year, but I can do it every other year or every 3rd year, just in terms of the logistics. The policy should be the policy, but just from the administrative side as a user, and I would say I get that this is important and people need to hear it as often as they can, but I still kind of have a bias toward longer sessions if possible, just because these are complex topics and it takes a while to develop them sometimes. So however this rule might encourage that is something that I would encourage the group to think about.
I gather, Peter, it's administratively, it'd be better for you all to have everybody reporting on a 3-year basis rather than reporting annually, but having some of those requirements only on a multi-year basis, right?
Yeah, I mean, it would be one of the reasons for potentially moving to a 3-year reporting period is that we would have a third of the bar reporting every year, which would be easier to administer. But it also, I do think, gives some more flexibility for lawyers to choose how they want to take their courses in terms of length of courses, and treats them, it removes 2 years of having to do an annual report that lawyers find seems to be unnecessary. If they can see that they've satisfied their requirements, why do they have to send in a report saying they've satisfied their requirements? And so as far as Jim, what you were saying in terms of kind of making it an either or, it's a little harder because then we have to code it in a way that allows it to be satisfied in a 3-year period or annually. And so we'd have to be able to track back to see if a lawyer has satisfied it the year before, and if not, then they have 2 hours still required. And I think it would be a little more difficult. We could certainly make it work. My preference would be to make it as simple as possible, and that if this subcommittee wanted to at least have an average it out to be at least 1 hour a year. However, the CLE board then redesigns its rules, it could average out to that. And if they don't redesign their rules, then it could be 1 a year, and we could look at potentially requiring it like we do substance abuse, where it's every 3 years you have to do 3 hours. But I don't know if someone would satisfy that by doing 3 hours over the 3-year period. We'd have to code it that way, so they could do it either way.
So right now you can carry over things, right, if you don't need them for a particular year. So if you had an annual requirement, but you took a 3-hour course and you had enough hours that you didn't need it for your other requirements, you could carry that over under the current system. Is that right?
Yes. If you had taken, it depends on how we design it, but if for instance this was an annual requirement and it was one of its own columns as a requirement, and you took 2 in 1 year and you carried it over, it could satisfy your requirement for the next year.
Okay.
If we were to switch to this 3-year reporting requirement, my proposal would be that we eliminate carryover completely, and that you reset every 3 years, no matter what you've done. That would really simplify things. The carryover stuff certainly creates a lot more of a headache for our administration of the rules. And that would guarantee that you're taking them at least every 3 years and not loading up in 1 year and then not taking CLE for 4 or 5 years because you've loaded up 72 hours in 1 year, and then you're clear for 6. So that's the unfortunate thing, and what we talked about last time. It's a little hard to have this discussion in the abstract because we don't know what the CLE board is going to do. So my recommendation would be that this board comes up with something that would be usable by the CLE board no matter what direction that they take.
So if you got a proposal from this group that said an hour a year, however you end up doing it, is what the group would recommend, then you would have the option to either cluster that, to use you'd have to take that and then apply it to whatever system you're working with. Am I hearing you right about that?
That's right. And obviously the CLE board, it was not bound by any recommendation of this subcommittee. So if the subcommittee recommended an hour a year, or an hour a year, or an average out to an hour a year of requirements, then the CLE board could take that and design their new program, their new system as they need it with that in mind.
My personal preference, if there's a choice, is an average of an hour a year is more flexible, and would make more sense to me than a mandated single hour every year. But
if we kept the annual reporting requirement, an average of 1 a year would end up being annually.
Okay.
So that, or 2 hours every 2 years or something like that. But I think that gives a lot of discretion. It certainly indicates this subcommittee's desire that this is taken often and regularly.
Then,
I'd go
Peter,
along.
do we need a motion to send to the CLE board about the requirement that this training be at least 1 hour per year to begin with the 2021 year, absent a change in the reporting requirements?
It will be the 2022 year, unfortunately. And yeah, so I think that you would want to have two recommendations in this front. One would be that all lawyers be required to take this course, take at least 1 hour in the 2022 CLE year, and then that the and as an ongoing requirement that the course be at least an average of 1 hour a year going forward.
Didn't we just pass the recommendation that the course be required?
I think we just passed the definition itself. I don't think
Okay.
that's the actual requirement.
All right. Then does anyone have a motion regarding a requirement for members of the bar?
Well, I'd make a motion that we recommend to the full CLE board that all lawyers be required to take this diversity, inclusion, and elimination of bias training. And second, that the requirement be that it be at least average at least 1 hour per year, but not necessarily, and that everyone be required to take at least 1 hour in the 2022 reporting year.
A second.
We have a motion and a second. Any further discussion? Very well. All who favor the motion say aye.
Aye.
Aye. All opposed, like sign. Motion carries and will be reported to the Board of Directors of Continuing Legal Education.
George, if I just real quickly, I think what I would like to do is put together these motions along with a brief report, draft report of the actions of this subcommittee, send it out to you for everyone for their review. And then, George, do you think we might need to meet to adopt the report of the subcommittee? Or we could just send an informal, you could send the report of the subcommittee without it being adopted by the group.
Does anyone object to my sending it to the CLE board without a further meeting of the subcommittee?
No.
No objection.
Okay. Then let's do that, and then we'll need to schedule a meeting of the CLE board between now and the October council meeting.
Yep, and that's already scheduled, George. That's the next meeting of the CLE board is going to be Friday, September 25th.
All right. Very well.
Which was the first date of the retreat that we were going to be having.
Right. So, Peter, do you have anything else?
No, I did actually wanted to share one thing that Judge McGee sent me just as an example of something that the judges are doing in this realm. Let me see if I can find it. Here we go. There's the Conference of Superior Court Judges is having a training in September, and about implicit bias is one of their sessions, and it's going to be I think a really great
program is focused on that.
Yeah. Right. The entire conference is focused on it. Right.
Actually, I've been involved in planning that. It's a 3-part program, actually.
That's great.
So we've already had one 3-hour session. We had 100 and something Superior Court judges, and just for your information, the first session was Frank Baumgartner, a political scientist at Chapel Hill, reviewing the data he's gathered on things like police stops and charging disparities. And then we got data from the Sentencing Commission on sort of racial classifying sentences by defendants and the data they have. And then I did the last part on public opinion and what it tells us about the public's trust and confidence in the system right now, especially with respect to race. And then the second session is the one you see here, which will be a session on implicit bias for the Superior Court. And then the third session, which we're still working on, will be focused on this question of what can you do about it? What's your job as a judge, and what can you as an individual judge do about talking about racial equity in the justice system? So it's been really wonderful. And I'll say this came from the judges. You know, I mean, we've been working with them, but it sort of is that, reminds me of that Gandhi quote, which is, you know, there go my people, I am their leader, I must find them. Because that's our job, has been to sort of help the judges work through their educational initiatives, and they've done a really nice job on this. So, and the district court judges have expressed an interest in doing something similar, and we recorded the session so that if worst that can happen is they can watch the recorded Zoom session, but they want to do something as well. So there's movement in the air, which is nice to see, actually.
Good. Judge McGee, thank you for sharing that as well.
Sure.
Does anyone else have anything to bring before this subcommittee?
I just want to thank y'all for taking an initiative and working through what are, you know, pretty challenging issues, in both in terms of the content and how you deliver it in terms of procedurally. So I appreciate getting a chance to watch you all work. So thank you for that.
Thank you for
your participation. Thank you for your participation, as well as everyone else. If there's no other business appearing, I'll declare this meeting adjourned.
Very good.
Thank you all for attending.
Thank you,
Be
George.
safe, everybody.